I'll just give a...
As a member in charge of the bill, I have told you.
Madam, I'll just give the brief context in which the moving of this bill is a constitutional necessity. Under the Constitution, the legislature of every state shall have to pass its own budget. Now, as far as the state of Uttarakhand, and I'm not, I should not be misunderstood because these issues are pending even before courts, and notwithstanding what the courts decide, the passage of this bill is a constitutional necessity, otherwise there will be a grave crisis as far as Uttarakhand is concerned. On the 18th of March, the Vidhan Sabha of Uttarakhand took up the budget. It is now stated and alleged that 9 members of the ruling party voted against the budget. And therefore, simple arithmetic seems to suggest that the budget...
They have not voted. What the speaker said. There was no voting at all. The budget is passed on voice vote.
Voice vote is also a voting. Voice vote is also a voting.
आप बोलिए खड़गे जी टोकते क्यों? आपको चांस मिलना है बोलने. You will. Yes.
That's all right. That's.
आप अपनी बात बोलते समय.
Now, madam, since Mr. Khadke has raised it, let me give the facts. I didn't want to get into grey areas. 27 members gave in writing that we want a division. Thereafter, 36 members told the governor in writing that we have voted against the budget and we wanted a division. This is the first time in the history of independent India that out of 67 members present, 35 or 36 are giving in writing we have voted against the budget, and the budget is still declared to be passed. And therefore there is a serious doubt and a cloud whether a budget has been passed or not. After the budget has passed, the Speaker of the House has to certify and write to the governor that the budget has been passed, and the governor has to accept that. Now from 18th till the midnight of 27th of March, when the Council of Ministers recommended action under Article 356, no recommendation or certificate from the Speaker had come that the budget has been passed. On the morning of 28th of March, President's rule was proclaimed. Thereafter, on the afternoon of 28th of March, the governor received a certificate from a speaker on 28th of March, which is dated 19th of March, saying that I had already on 19th of March declared the budget to be passed. The reports of the governor prima facie say that there is a serious doubt and a cloud because the numbers seem loaded against the budget. The fact that 9 people have been disqualified means that 9 have voted against the party and therefore against the budget. If 9 have voted in favor of the budget and the budget was passed, there is no reason why they should have been disqualified. The very fact that the Speaker has disqualified them itself is an evidence. You can't have it both ways. And 9 have been disqualified because they voted against the budget, so the government would have gone. Now there is I don't go into these areas. There is a serious doubt. On the 31st of March, having proclaimed President's rule, the central government is faced with a question: what happens to this so-called budget of the 18th of March? Is it passed? It is not passed. No appropriation bill has been authorized by the government as yet, or by the governor as yet. President's rule, when it was proclaimed, even a certificate from the Speaker had not come. And the state would have been pushed into a further constitutional crisis that with effect from the 1st of April, not a rupee to be spent by the state of Uttarakhand would have been authorized. So the secretariat would have stopped working. Their office here in Delhi would have stopped functioning. Salaries would not be payable. The High Court would have stopped functioning. If there are vehicles, nobody would put fuel into the vehicles because no money was sanctioned with effect from the 1st of April. And therefore, on the 31st of March, to avoid such a constitutional crisis, more as a matter of abundant caution, because what happened on the 18th of March itself was a grey area and highly doubtful that it had been passed, we issued an ordinance in support of the appropriation bill itself, sanctioning the appropriation for the year 16-17. It is that ordinance along with the budget which has come up for consideration before this House today. Now, since then, there were multiple challenges. One is a challenge with regard to the voting rights of 9 people, which we are not concerned in the debate today. The second is a challenge which some members of the Congress party have made, saying, no, this appropriation bill is not necessary because we believe that on 18th, the budget is passed, the Speaker's certificate is the final declaration to that effect. That matter has not even come up for hearing. We do not know what courts will do on that matter. There is a third matter where the High Court said that the proclamation under Article 356 is not valid. That matter is taken up in appeal. That matter was heard. And tomorrow, the Vidhan Sabha meets to decide what is to happen again. Now, various things can happen. The previous government can continue and be revived. A new government can come in. Or President's rule can continue. Now, this does not reflect on any of these 3 situations. If any new government is formed of either party, it will be entitled to call for its own session of the Vidhan Sabha, pass its own budget, and make changes to whatever we are doing. Alternatively, if President's rule were to continue, then I have asked for an appropriation for a period of 4 months, so that the expenditure of the state meanwhile can go on. And even if a new government comes in as a result of what happens tomorrow of either party, with effect from 1st of April till the Vidhan Sabha passes its budget, again, because of this cloud of 18th, the expenditure undertaken has to be sanctioned. And that can be only sanctioned under this budget. And therefore, irrespective of what happens tomorrow, if there is a new government which comes in or an old government which comes in or President's rule, the due course of the Constitution will follow. But we don't want in any of these situations there to be a constitutional crisis, that tomorrow a situation comes where expenditure with effect from 1st of April has not been sanctioned. Therefore, as a matter of abundant caution, as a constitutional necessity, we should approve the budget, the appropriation for a period of 4 months, and the ordinance which has been issued. In case there is a popular government which is installed in the state, it will be entitled to call its own Vidhan Sabha session and then correct whatever changes they are making. We are not making any detailed provisions itself, but we are just providing for the expenditure and the receipts itself, so that the constitutional necessity itself can take place. Now, this is not contingent on what happens tomorrow. The only area it is contingent is, because there is a serious doubt, the Congress party may well contend that 18th the budget was passed. Prima facie the number suggests that it was not passed. And therefore, we can leave that dispute as a political contention between the two of us, but this is a constitutional necessity where the Lok Sabha has its own duty to perform. And that is why I am recommending to this House that these proposals of the government be accepted.
Shri Gaurav Gogoi. Yes, what is it, Gaurav Gogoi?
Small point. Because I am concerned, because this is involving the Speaker. Now, as we know, in this House, the Speaker is supreme. When we pass the budget in this House, it is you, Madam, who certifies that this budget has been passed. I am not going into the sordid tales of horse trading allegations made on... Just one moment.
Yes.
The Speaker of the Uttarakhand Assembly gave in writing that the budget has been passed by the Assembly. And if I go by the recent rates in court judgment, the Speaker's opinion in any matters regarding legislation, defection is final. Just today, I may inform you, Madam, you may already be knowing that today the Uttarakhand High Court has held that the anti-defection action against the 9 MLAs, dissident MLAs by the Speaker was correct, and it has been upheld. So my contention is that we should do nothing that impinges on the absolute authority of the Speaker at the center or the state to interfere in the matter. I think that yes, what Mr. Jaitley has said as a responsible finance minister, it is his duty to say that, see that administration does not come to a standstill, that the cars can be fueled, the secretariat may open, etc. He is taking care of that contingency. I am talking of another contingency. If a speaker says, yes, the budget has been passed, he says that prima facie it appears that 9 people did not vote. That is prima facie, it has no proof. In a voice vote, who knows whose voice is the loudest? 2 people may shout louder than 20 people. Okay. So my contention is that in such a situation, we should not have hurried to have the appropriation bill regarding Uttarakhand to have passed. Because there is a question of upholding the supremacy of you, Madam Speaker, and the Speaker of it. If you change the law, change the constitution, that if you give the election commission power to decide on anti-defection, that's a different matter. The law as it stands today is that with regard to giving certificates, like if you give a certificate that this is a money bill, this is last word. Not even the President of India can interfere. If you give a certificate that these are people who are disqualified on grounds of anti-defection law, nobody up to now can do anything about it. If the Uttarakhand speaker gives a certificate that the budget is passed, normally that should, whether he did it in good faith, whether he was correct, whether the drama was sordid, whether etc., etc. I don't want to go into this. I want your considered ruling on the matter regarding the supremacy of the speaker in the house and in the legislative business. That's all.
Gaurav Gogoi.
Because this issue repeatedly arises, I think we should set it at rest. No, you are dealing with I substantially agree with what Mr. Saugata is saying. Article 212 says clearly, the proceedings of the legislature are not to be questioned in any house before a court. And therefore, when a speaker gives a ruling, the mandate of the constitution is that speaker's ruling cannot be questioned in court. These days, I find that Mr. Saugata is very charitable towards the principal opposition party. No, you are. You are. Even when your party outside this house and in the other house strongly opposes them, you alone are seen supporting them. I've seen it on more than one occasion. So can I?
Yes.
Now I'll tell you where he goes wrong. Where he goes.
Please अभी इस बात पे चर्चा मत करो. Yes.
We have said big thumbs to them. 19th May will showing the results.
Thank you, Madam.
Yes.
Where is the difference? What do you do? Let us take a hypothetical situation. A budget or a legislation itself in a state assembly is defeated. The speaker says, even though the majority in front of me has defeated it, I declare it passed. If Mr. Saugata is right, then the constitution is helpless. Please. Now, speaker is the master of the house. Members in writing demand a division. Members orally demand a division. The proceedings of the Vidhan Sabha indicate a division was asked for, but I declared it passed. Please have the patience. Now that you have taken up their brief, you must get the answer. Now, what has happened? Can under Article 212 the court go into it? The answer is no, the court still can't go into it. You are right. But under Article 356, there is no greater violation of the Constitution than a violation where a speaker wrongly interprets the arithmetic and a government which should have gone that day he saves the government by wrongly counting the arithmetic. Now please understand, if a budget fails, the government has to resign. A speaker declares a defeated budget as passed. Is it failure of the constitutional machinery under Article 356? The answer is yes. Can a court go into it under Article 212? The answer is no. So you are absolutely right. The Constitution, if a speaker misconducts himself and declares a failed bill as passed, the court will still have to accept that. But the President's satisfaction under Article 356 is not limited by limited powers of the court under 212. The President can still say, this is the best example of the failure of constitutional machinery, that a failed bill is being declared as passed, a government which should have fallen that day is being allowed to continue. So so this was a case where it's nowhere our case that under Article 212 the court should go into it. The President took cognizance of this, and the President, that is through the Council of Ministers, came to a satisfaction that 27 plus 9 is 36. 36 constitutes a majority in a house where 67 people are present, and therefore if 36 say I have voted in writing against the bill, the budget, and the speaker declares it passed, that's a failure of the constitutional machinery, and the governor therefore has rightly not given assent to the 18th March bill. Now, in the absence of governor's assent, there is no budget, there is no appropriation bill, and therefore the state will be pushed on the 1st of April into a constitutional crisis, and it is therefore required that the centre steps in, and the Lok Sabha under Article 356 does its own duty and passes the appropriation bill of the state.